The Co-Signer's Guide, what nobody tells you before you sign. Every bail bond has two people at its center: the defendant, who needs to get out, and the co-signer, who makes it possible. If someone asks you to co-sign a bail bond, they are asking you to do more than a favor. They are asking you to enter into a legally binding financial contract that could affect your credit, your property, and your savings for months or years to come. Most co-signers walk into a bail bond office focused entirely on getting their loved one out of jail. They sign quickly, they ask few questions, and then, weeks or months later, they discover obligations they never fully understood. This is the guide that every co-signer should hear before they pick up that pen. Let's start with what co-signing actually means in legal terms. When you co-sign a bail bond, you sign a document called an indemnity agreement. This is a contract between you and the bail bond company. In this contract, you agree that if the defendant fails to appear in court, fails to comply with bond conditions, or otherwise causes the bond to be forfeited, you are personally responsible for the full bail amount, not the 10% premium you already paid, the full bail amount. If the bail was set at $20,000 and you paid a $2,000 premium, and the defendant skips court, you are now on the hook for $20,000. The bail bond company has a legal right to pursue that amount from you. This is not a scare tactic. This is the contract you sign, and it is enforceable. Now let's talk about collateral. Depending on the bail amount and the risk profile of the case, the bail bond company may require collateral in addition to the premium. Collateral can include a vehicle title, real property like a house or land, cash deposits, or other documented assets of value. If the defendant complies with all bond conditions and shows up to every court date, your collateral is returned after the case reaches its final resolution. The timeline for return is typically 2 to 6 weeks after the case is closed, though the exact timing depends on the specifics of your case and the type of collateral pledged. But if the bond is forfeited, the bail bond company has the right to seize that collateral to cover their financial obligation to the court. If you pledged your car title, they can take your car. If you signed a lien against your house, that lien is enforceable. Here is what most co-signers do not ask, but should. Question 1. What are the specific conditions of the bond? As a co-signer, you have a right to know what the defendant is required to do. Curfew, drug testing, no contact orders, travel restrictions. If the defendant violates any of these and the bond is revoked, the financial consequences flow to you. Question 2. What happens if the defendant is arrested again while out on bond? A new arrest can trigger revocation of the original bond. This means the co-signer's financial obligation activates even though the defendant was already in jail when the forfeiture occurred. Question 3. Can I remove myself as a co-signer? The honest answer is that it is not simple. Once the bond is posted, you cannot just call the office and say you are done. The options for removing yourself are limited. You can request that the defendant be surrendered back into custody, which ends the bond and your obligation. Another qualified co-signer can replace you, though this is rare. Or the case can resolve naturally through conviction, dismissal, or acquittal. Question 4. What is the timeline for getting my collateral back? Ask this before you sign. A reputable bail bond company should be able to give you clear information about this. If they are vague about it, that is a red flag. Question 5. What are the early warning signs that the defendant might not comply? This is a conversation worth having with the bail bondsman. They have seen thousands of cases. They can often identify behaviors that signal non-compliance before it happens. If the defendant stops returning calls, changes their phone number, moves without telling anyone, or starts acting erratically, those are signals that your financial exposure may be increasing. Here is the most important piece of advice for any co-signer. Stay involved. Do not sign the paperwork and disappear. Keep communication open with both the defendant and the bail bond company. Make sure the defendant knows their court dates. Help them set reminders. If you start to feel concerned about their behavior, contact the bondsman immediately. A good bail company stays in touch and is ready to help. Co-signing a bail bond is an act of trust. It is an act of love in most cases. But it is also a financial transaction with real consequences. Going in with your eyes open does not make you less supportive of your loved one. It makes you a better protector of your family. At Freedom Bail Bonds, we walk through your initial bail packet and answer your bail questions along the way, even the uncomfortable ones. Because we believe that an informed cosigner is a better cosigner, and being informed can help support a better outcome for everyone. Freedom Bail Bonds, 24 hours a day, 7 days a week. 9152655650.